This is Michael Popok, Legal AF After Dark. There's an open rebellion between the United States Supreme Court sitting in Washington and southern state federal courts who are just thumbing their nose at the Supreme Court and ignoring all of their, not just pronouncements, their orders, their judgments, their decisions, their precedent that they have to follow about voting rights in America, about Section 2 of the Voting Rights Act, and whether black and brown and disenfranchised people are going to have any rights in this country when white majorities try to shove down their throats, or worse, voting maps that are obviously racist. Yes or no, thumbs up or thumbs down. The North versus the South, I thought we already resolved those issues, but apparently not according to certain federal judges in the South, and we debate it. Well, it's not really a debate. We're all on the same side on this issue. Ben Meiselas and me, trial lawyers, practicing. We do this in one place and one place only, on the MeidasTouch Network on Legal AF. Take a listen.
Topic on the Civil Rights Act of 1965 and how the Supreme Court and right-wing courts and the Court of Appeals have worked to gut it. One thing I want to talk about this as we talk about this horrific decision by the Eighth Circuit Court of Appeals and its implications, just talk quickly about the Voting Rights Act of 1965. It was passed during the Civil Rights Movement. It was signed into law by President Lyndon B. Johnson, and it sought to secure the right to vote for racial minorities throughout the country, especially in the South. It's been amended, I think, about 4 or 5 times, expanding its protections. It was a bipartisan legislation when our government worked and we didn't have MAGA Republicans just trying to blow everything up. I mean, just think about it right now. We got a situation where MAGA Republicans barely can pass a continuing resolution and want to attempted to put America into default. And every time it's like the most basic task of, hey, can you pass like legislation just to fund the government, like the floor, the bare minimum task? Just think about this right here. In the House of Representatives, the Civil Rights Act of 1965 was approved by a vote of 328 to 74. There were 217 Democrats and 54 Republicans who joined. In the Senate, it passed 79 to 18 with Democrats 49 Democrats and Republicans 30 Democrats. Just want you to think about that. Oh, let me just revise the House of Representatives. It was 217 Democrats for, 54 against, 111, sorry about that, 111 Republicans joined Democrats, so more than 54. It's as bipartisan of a piece of legislation that you can get. So you think about that was able to be accomplished in 1965. And one of the most kind of potent tools of the Civil Rights Act was something called pre-clearance, where when state legislatures would engage in these racist gerrymandering, our Congress, our federal government recognized that you have to deal with that. And there has to be mechanisms to stop that. So they actually created 2 mechanisms, double protection, if you will, against state legislatures, specifically those in the South, doing racist gerrymandered maps to disenfranchise minorities, specifically black voters. And the main potent tool that was in the Civil and the Voting Rights Act of 1965 was something called pre-clearance in Section 5, where a 3-judge federal court panel or the Department of Justice would have to approve the state legislature's map to ensure that the maps were not racist gerrymandering. And then once they were approved, they could take effect. But then that was gutted. And how was it gutted? Remember, this stuff doesn't just happen overnight. So in 2013, there was a case known as the Shelby County decision. And in the Shelby decision of 2013, they ruled that the pre-clearance formula in Section 4 was itself racist. And it's part of that argument that it was racist against white people is what they were saying by trying to stop racism. That's an oversimplified view of it, but that's basically what they ruled. So they said the formula is gone. So if you eliminate the formula for pre-clearance, you then can have preclearance. So it was a way for the Supreme Court, a right-wing Supreme Court in 2013, to get rid of preclearance by not getting rid of preclearance, but by getting rid of the formula. So then the only tool, as we had an updated census, and now all of these states are now, with the new census, are now gerrymandering their maps based on the new census, which was done during COVID. The only tool is a private cause of action, a private citizen or a civil rights group suing. The problem with that, though, and we've seen it over and over again, is that takes a lot of time. The burden is on a private citizen or organization to now challenge the state legislature's racist map, which our Congress back in 1965 recognized. Here's what the legislatures are going to do. If you leave the Alabama state legislature, they're going to carve up that state and disenfranchise black voters by giving them no congressional district, or maybe one where the African American population merits 2 or potentially even 3 congressional districts. Our Congress knew in 1965 this would happen. And then when there would be a private lawsuit that now have been filed by these civil rights groups, what happens? They take a long time, and as they get close to an election, the Supreme Court has invented this doctrine called the Purcell principle. They just make these things up, basically. And under the Purcell principle, the Supreme Court goes, you know what? We're too close to an election. We've got to let the map by the legislature stay in place, even if they eventually say, wow, this is a blatantly racist map. So what happens in the elections is, then you have elections with the racist, unconstitutional, gerrymandered map because the Supreme Court says, let that happen. And then you have people who are elected. That was the tipping point of the midterm elections. The only reason why MAGA Republicans took the House was because of the gerrymandered districts that have since been held to become, that has since been unconstitutional. And then even when the private organizations succeed in their lawsuit, like we saw in Alabama, what happens, then the state legislature doesn't even acknowledge what the Supreme Court does. So then a district court has to appoint a cartographer to go make the map, and that takes time. And if you get close to the election, then the Supreme Court said, well, we must probably have to keep it in place. That's what the MAGA Republicans rely on, because preclearance was killed based on the formula being determined to be unconstitutional in 2013. So now you have this, remember I said there was double protection. Number one, preclearance. And then even if the preclearance didn't work, then you'd have a private cause of action where civil rights groups can bring lawsuits. So now after preclearance has been eliminated, what is the right-wing courts challenging? The private cause of action, and saying, actually, there is no private cause of action. And this was what the Eighth Circuit Court of Appeals just ruled. This is a ruling. There was 3 right-wing judges on this panel. There was 1 Trump, 2 George W. Bush. One of the George W. Bush judges was in the dissent. And this is what the ruling held. It was on Monday. The Eighth Circuit Court of Appeals, whose rulings apply to Arkansas, Iowa, Minnesota, Missouri, Nebraska, North Dakota, and South Dakota, said the following. For much of the last half century, courts have assumed that Section 2 is privately enforceable. A deeper look has revealed that this assumption rests on flimsy footing, is what they said. And then the judge in dissent, Judge Smith, who's a George W. Bush appointee, it was a 2-1 decision, says, until the Supreme Court rules or Congress amends the statute, I would follow the existing precedent that permits citizens to seek a judicial remedy. So, Popok, you see how they, again, I wanted to give the history of the Voting Rights Act of 1965 so people know how far we've regressed. Because in 1965, the House and the Senate came together. They understood it. And now you have a situation where the House can't even pass a spending bill under these MAGA Republicans, and the right wing's doing everything to undermine the rights that were held to be like so obvious. So they gut preclearance, then they try to gut the private cause of action. So if you gut both of those things, in essence, what the right-wing courts are saying is that actually, you see, the Civil Rights Act signed into law by Lyndon Johnson the Voting Rights Act signed into law by Lyndon Johnson during the Civil Rights Movement. You see, it was just a pronouncement. It was just a lofty ambition. There's no ways to actually enforce this thing. It was just it was just a
Aspirational.
aspirational declaration, and it's like, and that's why everything. And I wanted to again give the history because it's all gaslighting. It's all about raw power for these MAGA Republicans. And they'll come up with the sociopathic kind of frameworks, small government, originalist, textualist, conservative. But at the end of the day, it's all BS. It's power. They want to gut anything that actually reflects an equal playing field. And we see it here.
Well, you got, by the way, people should apply for credit because that was a masterful presentation of the Voting Rights Act and the Civil Rights Act and everything that Lyndon Johnson and those from that era worked so hard to put in place that have been piece by piece disassembled before our very eyes. But we have two things going on here. We got an open rebellion of MAGA right wing and primarily courts and appellate courts in the South who are rebelling even against this right wing Supreme Court and their own pronouncements. So we got that going on. And when you have open rebellion among the federal courts who aren't respecting their bosses in the Supreme Court, that's a big problem. It's a big problem under our system of government, under our three branch system, and the role of the Supreme Court in being the ultimate lawgiver of the land. So I want to talk about that too. What we're seeing and the why we're seeing it now. Some people might be thinking, why are there so many MAP cases that are being up in front of these appellate panels and ultimately the Supreme Court? I don't remember a period where there were so many of these MAP cases where the MAPs are disenfranchising Black and brown people. At least that's the argument, in violation of the Voting Rights Act. And you and I at the beginning of the year, the beginning of 2023, posited this question: is the Voting Rights Act, and particularly Section 2, on life support or not? Because it had been so chipped away by prior Supreme Court precedent that we really questioned whether, as you said, it was anything more than aspirational at this point. Good news was over the summer, we had the ruling in the Allen versus Milligan case that seemed to breathe new life, led by John Roberts and even by Brett Kavanaugh, into the Section 2. The ability of a civil rights group or somebody that's a voter to sue under Section 2, have standing to go to court to sue under Section 2 and argue that a voting map is racist in violation of Section 2. And in Alabama, the Supreme Court, in a 5-4 decision in that case, said Section 2 is fine. They also implicitly acknowledged that civil rights groups, the NAACP and other civil rights organizations, can bring the case in their name to challenge because of the type of case that it is. It doesn't have to be just the Department of Justice or the federal government, which depends on who happens to be the president. Because the thing that we haven't talked about here is, if the Eighth Circuit is right, and they're not, and I believe the Supreme Court will rule that they're not, that despite 50 years of precedent, and the U.S. Supreme Court just this past summer acknowledging that civil rights groups can bring the case on behalf on the issue and not have to wait around for the Department of Justice to do it or the federal government, if they are right and Trump or somebody like him gets back into power, they will dismantle the Civil Rights Division of the Department of Justice, and there will be no cases brought. The Department of Justice and the feds will be blind to violations of the Civil Rights Act because of who's in power in the White House. That's what happens. Even when a Trump is in office, the NAACP, the Southern Poverty Group, crew can bring lawsuits to challenge and then take their chances at the federal court, appellate court, and Supreme Court level, but not under the new thinking, the new teaching of the Eighth Circuit. Eighth Circuit, yes, it's a 3-judge panel, but it is binding law now for the states that you just identified, has just said, thumbed their nose at the U.S. Supreme Court, which I think is going to get them into trouble. We'll talk about that in a minute, and has said, NAACP can't bring a case under the Section 2. What about the dozens and dozens and dozens of cases that say they can, including the Supreme Court in the Alabama decision this summer? No, ignore those. They can't do that. We never get to the merits because they don't have the standing to bring the case. And what that is a signal. When you hear that, that means we want the executive branch, whoever's sitting in the president's seat, to have the ultimate power through his Department of Justice to decide which, meaning none, violations of Section 2 he'll go after, or she'll go after, and not any old group that just comes along and wants to argue that the Section 2 has been violated. This is the open rebellion I'm talking about. We've seen it over and over again. We've seen Mississippi thumb its nose at the Supreme Court and said, "Oh, you told us we had to have a map with an extra black district? Well, F you, we're not doing that." And then the Supreme Court has to say, check your paycheck. You're part of us. We're your boss. You do this. We're not going to allow open rebellion. Even this Supreme Court, even Clarence Thomas in Alito said that's probably a bad thing when federal courts don't follow Supreme Court precedent. And they just did it again on the Eighth Circuit because the Alabama decision, if it stands for anything, it's that a civil rights group has standing to bring a case under Section 2, exactly contrary to what the Eighth Circuit just came up with. Now, Strass is an interesting cat as the person who wrote the decision in the Eighth Circuit. He came out of Minnesota. He's practicing in his religion. He's very religious. He's the first openly, I forget. I think he's Jewish. Whatever his religion is, he's a practicing Orthodox Jew, and he's a Trumper. And he wrote the decision, and he got one other person, Gruender, to go along with him. And the only person who didn't is, yes, a Bush appointee, but also the only African-American that's sitting, or at least on that panel. And so Smith said, yeah, I don't think that's the right thing to do here. Now, the question is, does the organization that lost, the NAACP, do they go for a full en banc ruling by the Eighth Circuit, meaning all the judges of the Eighth Circuit, or do they just take this obviously wrong decision and take it up to the Supreme Court? Now, the interesting little twist here is the Eighth Circuit, with all the states that you identified, is the Supreme Court justice that's responsible for the Eighth Circuit is Kavanaugh. Kavanaugh just joined with Roberts and the three liberal members of the Supreme Court on the Alabama case. So this is the raw. I mean, Kavanaugh should instantly let this case that's on appeal go straight through to the U.S. Supreme Court. And then it's going to be up. We know that Clarence Thomas has been itching to get rid of the Voting Rights Act in Section 2, of all people. He's itching to get rid of it. He's already said, and Kavanaugh said in his concurring opinion in the summer in the Alabama case, that he doesn't think that the Section 2 to allow map supervision by the Supreme Court should go on forever. Time should take care of racism. Apparently, that's what happens in the Supreme Court world. Time solves and heals racism. Although that's not what we're watching in the streets and in society and any place else. But in the Supreme Court world, that you just the clock just has to go around more. And then all racism, we won't need any of these protections. And to answer my posit at the beginning, the reason we're seeing so many map cases right now is what you taught our audience about preclearance. Preclearance has now been removed in all of these states. These are the first maps off the first censuses that have happened since preclearance has been removed. So no more three federal judges babysitting Mississippi and Alabama and the rest of them. This is their first shot without training wheels, without constitutional oversight by a federal judge panel to do it right, and they do it wrong because their natural instincts is to screw the black and brown and disenfranchised person in their state. There's a reason that the state maps don't match the demographics of the state. 27%, 30% black. Why are the districts representing 12% black? Because the whites that are still in power, almost like apartheid, don't want to give power to the people in the state that deserve it and have earned it on the most fundamental right that you have under the Constitution, that even our founding fathers recognize is the right to vote and not be disenfranchised. And that's the thing that the southern states are like, nope, we're going to oh, we don't know more preclearance? Okay, give me a map that's all white. That is what I want. And then you get judges in these districts that say, yep, looks good to me. And if it's not good, let a president and the Department of Justice deal with it, hopefully Republican and not Democrat. I think the Supreme Court, when this finally gets there, is going to declare once and for all, as if it wasn't already precedent, that civil rights groups and others not named the Department of Justice or the United States of America have the right to bring cases under the Section 2 of the Voting Rights Act to call out disenfranchisement and racism in voting among these states. Because if you, like you said, if you eliminate both, if you get rid of preclearance and you don't allow people to sue under Section 2 and you wait around for the federal government and it's in the wrong hands, you will never see it and people will be disenfranchised forevermore.
And our Congress understood that in 1965. Think about that. Don't we want to progress as a society, expand voting rights, help people more? We've come to a place where the opposite is happening, and it's not a both sides issue, folks. And that's why I just want to give you the data, the history of it. I guess all of those Republicans who joined Democrats in 1965, I guess all of them were rhinos and deep state operative. No, it's just the change in the landscape right now in terms of what this MAGA movement has done is, I'll let you all decide for yourself, but I think it's ever present.
Well, there is an example, a teaser, if you will, of what we do week in and week out, twice a week, on the MeidasTouch Network on a show we like to call Legal AF. It's exactly what you think. And then if you like that, you'll love the 5 or 6 segments we do every week, 8 p.m. Eastern Time, Wednesdays and Saturdays on YouTube. Free subscribe to the MeidasTouch YouTube channel. And then you pick us up on audio podcast platforms, wherever you get your audio podcast from. And then we do hot takes about every hour on the MeidasTouch YouTube channel, where we sit at that intersection of law, politics, and justice so you don't have to, and bring you our collective knowledge, wisdom, and experience. So until my next hot take, until my next Legal AF, of course, this is Michael Popok reporting.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.